Today's podcast, responding to the notice of proposed summary judgment. Now, if you are a federal employee with an existing case, you know exactly what I'm talking about. There has been a plethora of these sua sponte, which means by the court, pre-discovery, pre-deposition, summary judgment motions. There's a combination of forces that I think has caused this. One is that administrative judges are perhaps unjustly under great pressure to reduce their caseloads. And there's no incentive for agency responsible management officials or RMOs to be truthful in their EEO affidavits. These conditions have created a potential for a storm of injustice, highlighted by a recent decision in which an administrative judge in Washington, D.C., Judge Douglas, dismissed a case without discovery and a parallel case in which discovery did go forward against the same RMOs on the same issues, revealed the RMOs were untruthful in their EEO affidavits. So we know that the judge's decision was wrong, not because on appeal the Office of Federal Operations said so, but because the actual RMO and other witnesses were allowed to testify by a different judge. And that deposition testimony revealed these RMOs were untruthful. Thus, that complainant's case should have gone forward. And this is what happens. And I'll just delve into, before I talk a little bit more about that case, the kinds of issues that these notice of proposed summary judgment motions are issued. So the first thing is going to be anything on deadlines. Anything where the federal employee missed the 45 days. Sometimes people file these cases years later. They're not aware of the 45-day requirement. We are not going to help you in most of those cases. Nobody will, because it's a filing deadline, and in those cases perhaps summary judgment is warranted. Now, we do have a podcast, how the employee is misled by the 45 days or about the 45-day filing requirement, and we would urge you to listen to that podcast and understand how sometimes there can be exceptions to that. But putting that aside, unless there's an exception, generally speaking, those motions are going to be justified. Another category, there's no real adverse action against the employee. There's a letter of counseling which had no effect on the employee's career. If your case is about that and you get a notice of a proposed summary judgment, you will probably lose. But barring those kinds of claims, generally speaking, what's going to happen is the court will say those words. We believe the agency has articulated legitimate reasons for X, Y, and Z. And what this Douglas decision did is kind of totally undermine that assumption. Now, in Douglas, and Douglas, I'm not saying my client's name out of confidentiality, so I'm just referencing it named after the judge who wrote this opinion. Basically what happened, there were two employees, let's call them Mr. Douglas and Mr. Lee, and they were under the same chain of command as supervisor number one. And basically, these employees had developed a deep level of expertise in an extremely complex area of investigation. They were sent to Ireland for a master's program, and they each had a CSA, a continuing service agreement requiring them to keep working for around 3 times the length of the program, and they were all comfortable with that. Supervisor, we say, discriminated against them, moves them, and the supervisor, worse than moving them out of the cybercrime center, is she reports them to the Office of Professional Responsibility for breaching this CSA, which is unbelievable. But she doesn't say any of this in her EEO affidavit. So in her EEO affidavit, she says that the reason that she reported them was because the CSAs look like they were forged. Okay, so we say, hey, first you reassign these guys and you shouldn't have, and you cost them all kinds of time and energy and future career prospects by eliminating their special knowledge that they had. And the next thing is you reported them for something they didn't do. And of course, the judge here says, well, I've read her affidavit. I believe her, the supervisor, that she had a legitimate reason to report these people, so on and so forth. And he dismisses the case. The second judge, though, allows the other guy to go forward. And when the other guy goes forward, we take depositions of the other people, and we find many, many inconsistencies and some just deliberate untruths. We took a deposition of the man who conducted the investigation for OPR. He said the whole thing was incredibly suspicious. He said the reason they were first investigated was they had committed fraud, not on the forms, but they had committed fraud in leaving their department that they had promised to stay in. And he demanded the 3R letter, either resign, relocate, or retire, or whatever, and the agency couldn't provide it. He even wanted to investigate the supervisor, and he wasn't allowed to. The supervisor wrote in her affidavit she relied on the recommendation of some other manager. We took a deposition of that other manager. The manager who allegedly gave this recommendation, after the manager says she read through the documents and they appeared to be forged. Actually, at deposition, she said she never read through the documents. She relied on the supervisor. Hey, we now have this case where we cite to that case's depositions what was in their EEO affidavits, in contrast to what was in their depositions, how they manipulated language in their EEO affidavits, how they misled the EEO investigator, and how what they said, their actual misleading statements, actually did mislead the administrative judge. And we now use that template in every one of these notice of proposed summary judgments, and our firm has that. I don't know how many others do, but this is an actual, before we even get to this case, and this is what I tell the court, before we get to this case, why do these people get the assumption of truth? Why is that? Why isn't this a case of, similar to what the court is doing, I think, is on a traffic accident case, intersection case, personal injury. The plaintiff claims he had the green light. The defendant claims he had the green light. And imagine an administrative judge just picking up that case and saying, you know, I've read these affidavits. I believe the defendant. And just what? We're going to throw out that case and there's no trial? I mean, are we going to end personal injury cases as we know it? Or the manufacturer says, yeah, even though we manufactured and designed this defective lighter that burned down some apartment complex because some kid played with it with a defective safety lock, hey, we did what we were supposed to do. We did our best. And therefore what? 50 people get killed and another 300 people get injured and there's all kinds of property damage. And we're going to what? We're just going to believe what the company said without any sort of trial, without any sort of deposition, without any sort of cross-examination. That's exactly what's going on right now at the EEOC. But that's not enough. I mean, even after you do that, you do have to show what the issues of fact are in your particular case. And we do that also. And we go through how there are comparators, how there are holes in the testimony, how somebody is, for example, complaining they didn't get a performance work plan. Everybody else did. And the supervisor's response is, well, I gave everybody an appraisal. He got an appraisal. Yeah, you know what? That wasn't the claim. The claim was performance work plan. He didn't get one. Why not? You never answered that question. And it's imperative that if you get one of these notices of proposed summary judgment, you deal with it, contact our office. We have the templates. We understand the entire process, and we can help you get through that motion and impress upon the judge the importance and value and the respect your case deserves. I hope you've been enjoying our podcasts we've been producing, and we invite you to please subscribe to our channel so you do not miss out on the latest legal developments.